Jared Regier for the state. Mr. Schrader, do you appear?
I'm here in pro persona sui juris, appearing specially, not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier.
Right from the start, Matthew Schrader doesn't sound like a typical defendant. Instead of a simple yes, I'm here, he launches into legal jargon, prop persona sui jurist, and appearing specially. This is classic sovereign citizen language, where the goal is to distance oneself from the court's authority. To most people listening, it sounds like nonsense, but inside the courtroom, it's a red flag. This is going to be a long day.
Correct, Your Honor.
Okay. All right, Mr. Schrader, can you still hear me okay?
Yes, I can.
All right, I'm having some issues here, as you can see. In count one, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
I will waive.
The judge lays out the charges: failing to register a vehicle and no proof of insurance. Simple misdemeanors, usually handled quickly. But notice how Schrader chooses to waive his right to an attorney. This isn't about money, it's about control. Sovereign defendants almost always represent themselves, convinced no lawyer can speak their truth. In reality, it often leaves them exposed because the law doesn't bend to their ideology.
On the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
All right. You have filed a written motion for subpoena of what documents from the Butler County
Subpoena
Sheriff?
Ducis Tecum.
Of what?
There are many items on there, and
so you don't know what you've asked them to bring to court?
Yeah, I have. I do. I don't have it in front of me, but it's a lot of the typical things like.
Here's where Schrader tries to flip the script. He tells the court he subpoenaed the sheriff's office for records, body cam footage, dash cam video, reports. This sounds smart, like he's fighting back, but the sheriff's office already moved to quash it. It shows the pattern. Sovereign defendants love paperwork battles, hoping to delay the inevitable. It buys time, but rarely wins the war.
All right, so you're telling me you don't want to plead not guilty today, you don't want to plead anything today. Is that what you're saying?
Right.
Well, you understand this is the hearing when that happens. We enter a plea at first appearance. That determines what happens from there. But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf, and we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me?
I'm asking you, sir.
How much time I need?
No, I mean how much time the whole hearing will you anticipate will be?
20 to 30 minutes.
All right, let's be safe.
This moment is telling. The judge asks how he pleads, but Schrader refuses to say guilty, not guilty, or no contest. Instead, he insists he needs evidence first. Courts don't work that way. The first appearance is exactly when you enter a plea. So the judge does it for him, not guilty. It's a subtle power check. The system won't grind to a halt just because one man refuses to play by the rules.
And that it be done before trial. And because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 Section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
Anything you want to say about your bond, Mr. Schrader, before I declare it?
I object to that since I appeared here as I was supposed to.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
$3,000 was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Schrader, you are ordered to appear at the time given by
The prosecutor seizes on Schrader's behavior, pushing for a $3,000 bond. Schrader objects, pointing out he showed up just as he was supposed to. He's not wrong, but the judge sides with the state. This is where his strategy backfires. The more he resists, the more the court tightens control.
the officers for booking and processing. Your bond will be set at a 3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with deputy in court security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post the 3,000 OR bond, then I very well may have to issue warrants for you. But right now, because you did appear when you were told, I'm going to make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Schrader?
I think I understand it.
Oh, very well. Look for that invitation on the breakout screen. And Destiny, if you'll put that on there for Mr. Schrader, for the officer in court security 2.
What time? So it's November 12th?
The motions hearing is November 12th at 1:30, correct?
1:30. Okay.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So Destin, if you'll just...
The judge explains bond terms with sharp clarity. You don't pay now, but if you miss court, you owe $3,000. It's both a warning and a test. For sovereign citizens, this is the ultimate contradiction. They don't recognize the system, yet the system holds them by the throat with consequences they can't avoid.